There's something funny going on.
There's something funny going on. There's something funny. Yeah.
Hi everyone, my name is Paul. Thank you for joining me. This is video 5 in my series of videos with regards to my case against the City of Dearborn in front of Judge Eugene Hunt. In this video, I'm going to discuss the hearing that occurred following my motion to compel in order to get the city to answer my interrogatories. As I mentioned in the last video, the city, right before the hearing date, did actually respond to my interrogatories, yet some of these responses were not complete or adequate. So I kept my hearing date and decided to discuss this in front of Judge Eugene Hunt. I was very pleasantly surprised when Judge Hunt took his time to go over each concern that I had in this hearing. This is my first hearing, and that was extremely helpful. Now, though I had many issues with the judge throughout the rest of this case, which I will of course get into much greater detail throughout these videos, this was very helpful to me. He didn't agree with everything that I said, of course, but he did agree with a number of the points that I brought up. I'm now going to go into some detail here as far as some of the examples so that you can see what happened in the courtroom during this hearing. I'm hopeful that this can give you a little idea as far as what to expect in your own hearing if you do have some type of discovery motion that gets heard. One of the questions that William DeBiasi objected to that I brought up to Judge Hunt was question number 10. I'm going to try to put that up here right now. This question dealt with repair work over the last 5 years to the site of the repair that was in 2017. Now, to remind the viewer of what I discussed in video 2 of this series, the city actually visited the site of the cave-in 3 times over 3 years, from 2015 to and including 2017, with 2017 being the year of the cave-in was finally repaired. Unfortunately, I was not provided with any documentation regarding the first 2 visits, despite William DeBiasi informing the court that he had given me all the documents that they had. Now, he at one point made the claim that they don't keep records of everything. While this seems correct, it doesn't explain why they have no documentation from their first visit to the site in 2015. During the visit in 2015, the city apparently had done camera work to look into the sewer to check for issues. I would have thought that they would have had their findings recorded somewhere. For example, the city had documentation from camera work done on my sewer in 2017, so they obviously do know how to find this documentation. Yet apparently, according to William DeBiasi, they didn't have this documentation from 2015. I'll get back to what happened in this hearing regarding William DeBiasi's objection in a second. In the meantime, I want the viewer to understand that this was important to my case, and yet I was never provided this information by William DeBiasi. It was important to my case because it would provide a comparison between the findings of camera work in 2015 versus 2017, the year of the repair. The city knew back in 2015 there was a cave-in. So what happened between 2015 and 2017? How do these images compare? Was there a failed private sewer in 2015 discovered by the camera work? If yes, why was it not considered hazardous back then as it was in 2017? Why didn't they attempt to fix it back then? If there was no failed sewer discovered in 2015, then there is no way that it could be the cause of the cave-in. I win the case. This was important and would have provided immense help to my case. Now back to his objections. First, Mr. DeBiasi objected because he thought that my definitions with regards to repair work and street and all this type of stuff here, that these definitions were not specific enough. He thought that my wording here could include the entire street. The judge cut him off and said, no, it's very specific. It's between my house and the house across the street. Then Mr. DeBiasi indicated that he did not understand what the word in between meant, or the phrase in between or between. You'll see up here when I post the transcript. Finally, Mr. DeBiasi objected to the relevance of this question. Surprising to me, the judge asked Mr. DeBiasi whether or not you can object to relevance in interrogatories. I actually chimed in here, if you'll see my response there or my question, because I was, I think, a little confused by that. A little note to the viewer here, when the judge is asking tough questions of your opponent, don't interject. Let that play out. So he asked this question of Mr. DeBiasi. In the end, the judge said that this is a very specific question, that it was not something that would be difficult for the city to provide. Had it been something that he felt the city would have difficulty providing to me, then he would have thought about it a lot longer. But because of this, he indicated that the city had to provide this information to me. Another question that William DeBiasi had objected to, in that in this situation here at the hearing, the judge ended up agreeing with him, was my question with regards to safety issues following the water repair, or more whether or not there was actually safety testing of the water after the water repair. This actually was an objection based on relevance, and the judge agreed to this. Now, I don't understand why one relevance was allowed and the other one wasn't, but again, I didn't argue that. But in this situation, relevance, that objection was accepted by the judge. The judge said this question was not relevant, and he said that if I wanted to go forward with this, I would need an expert in order to explain why this would be relevant. And considering the cost of my case, that was not going to be a very, may not be a smart thing to do. One of the things here is that I tried to do my best to explain why this was relevant, try to provide my theory on this, but I was so nervous, I did not do a good job, and I lost in that question. Another question that I brought up that had not been responded to properly in the interrogatories was whether or not the City of Dearborn official had been there for the entire time of the repair, including during backfilling. The city did not provide a yes or no answer, and that is one of the things that I wanted. I'll save you here all the reasons behind this question, but there was a theory that goes with it, and the judge indicated that the city had to answer this question. The judge indicated that this question, if not answered properly, would actually lead to depositions, which the judge was trying to avoid. Mr. DeBiasi was, as well as me. I would not have enjoyed doing depositions, and it was not worth it given the cost of the claim. When we were discussing this question, I actually, in this one, did a good job of explaining myself to the judge. And the judge asked Mr. DeBiasi to amend his answer, and Mr. DeBiasi indicated that he would indicate the answer is no. The city official was not there for the entire time of the repair. Unfortunately, Mr. DeBiasi did not do what he told the court he would do. He did not answer the question specifically whether yes or no. He just went ahead and, as you can see here, gave a more convoluted answer, and so I had to file another motion to compel in order to get him to answer the question as he had previously promised the court to do. The next hearing date was January 18th, and so I scheduled for that date. Unfortunately, following all this, the city filed a bunch of motions, and there was some other game playing, I guess you might want to call it, and so it kind of falls apart after this. I'll get into that in the next video. I hope you'll join me. Thank you.